Welcome everybody, and thank you for joining in today. Before getting started, I just wanted to briefly introduce myself. I'm Nishtha Pandey, Chief Legal and Compliance Officer at InvestaX and InvestaX. I am glad to be moderating this session today, and we have today with us an esteemed panel of lawyers. Before just proceeding, I wanted to give a little bit of explanation about the format of this webinar and also get the general disclaimers out. So in terms of the format, each speaker is going to be presenting for 8 to 10 minutes with a short and sharp presentation. And this webinar also, just so that everybody knows, is being recorded, and we are going to share a recording of the event with the attendees after the webinar. In terms of question answers, we are going to try to save all the question answers to the end and take them up during the question answer session. To just give a brief background of our audience today, we have lawyers, we have bankers, as well as fund managers and professionals from the digital asset industry attending this webinar. I would also encourage active participation from our attendees, and please feel free to share your questions, thoughts, and engage in conversation over the chat feature here. And our speakers would be willing to answer that, and even our teammates can take some of the questions. Yep, I think with that introduction, I think I'll pass it on to Julian, CEO and co-founder, InvestaX and InvestaX, to give us a brief overview of the company, the products and services, and what's happening in the tokenization space. Excellent. Okay, over to you, Julian.
Thanks, Nishtha, and thanks, Shefali, for setting it up, and for our esteemed speakers today. My name is Julian Pond. I am CEO and co-founder, InvestaX and InvestaX, Singapore and Bahamas-based platforms, predominantly focused on asset-backed tokens, real-world asset tokens, security tokens, a couple different names. So using the technology and the blockchain to digitize and tokenize equity and debt, and connecting them to the power of decentralized finance and the rest of the digital asset space. Sorry, just next, Shefali, please. So InvestaX is a Singapore licensed tokenization SaaS platform. So we have all the licenses, broker-dealer, exchange license, to allow any investment group or company to tokenize those assets in a customized manner, where we have the license, we have the tech, we can put up the client's brands, they can tokenize whatever they want, bring their investors to the platform, and legally and compliantly have a partner, and it's a low monthly subscription model. As Larry Fink says, and something we believe in, the next generation of private markets and securities is tokenized securities. Next, please, Shefali. So I wanted just to touch base. Again, some of the other speakers will be talking about the broader digital asset spectrum, including cryptocurrency, stable coins, security tokens, etc. I'll be focusing mainly just on the security tokens for the next couple of minutes. The reason why we're doing what we're doing, and why myself, my team, Alice, my co-founder, have been super bullish and 100% focused on this security token industry since it began, which was only about 3, 4, or 5 years ago, is that looking at the history of securities markets and public markets, every significant kind of expansion of capital came when new technology kind of married into the marketplace. More recently, electronic trading, recently being the most recent sort of 20, 30, 40 years, electronic trading, not stock trading off the floor, which obviously opened up to millions and millions of more people accessing these markets, and then a growth. We've had one thing I like to talk a lot about is the ETF structure, and why is that kind of relevant to today's discussions. When the first ETF launched in 1989, it was considered a failure, even though it raised about $6 million. Today, the ETF market, which is new technology marrying a marketplace, is a $6 or $7 trillion marketplace. So what do we believe? We believe that all equity and debt the private market assets will be tokenized, and what that will mean is we're going to see a whole new world of investment products. We're going to see a whole new, more transparent, more better, more accessible, more usable asset class, and we're going to see a huge explosion of value being created. Sorry, next. And what's really exciting about, again, digital securities, security tokens, they're all the same things, is that the marketplace is nascent, but it's now really growing this year. All major banks have already been tokenizing this and that, but the size of the marketplace is enormous, and we're just getting started. And that's kind of the real exciting part about the opportunity right now. Next, Shefali. And so why do we think it's important for real estate groups, private equity groups, venture capital groups, investment groups to be looking at this? Is because this is going to be the structure of all investments moving forward. Investing time and energy and resources to understand this, to tokenize an asset, will not only make you relevant, it will give you the insights needed to understand the challenges, but the opportunities, and start to develop investment products, new revenue streams, and make sure your company is what we call Web3 compatible as we move forward here. So what we like to say is that any traditional investment company, so anyone who's not in blockchain, let's just say that, is basically a Web2 investment company. What does that mean? It's a closed system. It's traditional finance only. It's paper-based securities. There's no real liquidity solutions, and there's no connection to all the rest of the digital asset space. What we provide is a partnership with technology and licenses to make your Web2 investment company Web3 compatible. What does that mean? It means you can issue your shares digitally as tokens. You can access liquidity solutions. You can connect your traditional finance, TradFi business and assets with the power and the innovations of decentralized finance. And it's a much bigger and much more interesting ecosystem. So that's what we're here to talk about. That's why our existence, that's why we exist, to bring that to the marketplace. Just quickly, if as one example, you're a real estate group, you want to tokenize an asset, there's only really three, four limited choices. You can either hire a tech company to tokenize your shares yourself, which is interesting, but it's very limited. You don't have all these extra licenses, but that's where the industry started. You could hire a token issuance company where you're just renting their tech, but again, tokenize your own real estate assets for yourself. Okay, that's interesting, but you are missing out on many other elements. You could take your asset to a security token exchange, one of them in Singapore, ADDX. You've got to give your assets, your investors, to the exchange. It's still fairly early, so there's very limited liquidity, and there's quite a significant cost structure. Or you come to us, where we provide the tech, the licenses, low cost, fast setup, and the only automated market making solution in the marketplace. And we're here to try to get as many investment firms, traditional investment firms, into the tokenization space as possible. And that's what we're excited to do. Sorry, what's next, Shefali? And so, what does that mean? It just means that you can KYC investors, you can issue your assets as security tokens. Investors can register, they can deposit cash, they can buy these assets, and they can trade these assets, all wrapped, or I should say, all under the watchful eye of the Monetary Authority of Singapore, who's extremely bullish on tokenization, as we think most regulators are, because tokenization for private markets brings more transparency, brings the elements of publicly traded assets. So it's more of what all the regulators want. That might not necessarily be the case for cryptocurrency, but certainly for tokenized securities, especially in Asia. Singapore, Hong Kong, Korea, Japan, the regulators are all getting very bullish on this, and this can be a huge opportunity. I think that's a wrap from myself, Shefali. So I wanted to make sure we stick to the schedule and pass it across, I think, next. And so I'm just going to roll it across. The next one, Shefali, Simone's picture, beautiful face. I wanted to introduce Simone. We trekked around the world 2 years ago when we built IXSwap, we wanted to try to find a friendly, qualified, regulated jurisdiction that was forward-thinking related to digital assets. And through a very good friend of mine, Gabe Abed, introduced Simone. Simone's been our trusted source out in the Bahamas, has helped us secure one of the licenses out there under the DARE Act, which I'll let her get into. So Simone, great to see you here. Thanks for coming. I know it's a 12-hour turnaround. I'll pass it over to you.
Simone, maybe I'll give a quick introduction about you, apart from what Julian said. Of course, definitely glad to have you here today with us. So I think the team knows about Simone, but I'll just speak a few words about her. Simone is managing director at Simone Smith Bean and Company. That's a law firm and a corporate secretarial service providing firm operating out of Bahamas and Bermuda and even United States. Simone is currently sitting on Bermuda's FinTech Legal and Technology Subcommittee. She is also a member of the Caribbean Blockchain Alliance. And today, Simone is going to be talking about the much talked about DARE legislation, as well as how the Bahamas regulator is tightening the leash after the FTX collapse. So over to you, Simone.
Simone, you are on mute.
You're on mute. Simone, you are on mute. Oh. I'll just write to her as well.
Simone, can you? Yeah, there you go.
Yeah.
Okay. Hi, can you hear me now?
Yes.
Yes.
Awesome. Hello, everyone. I am Simone Smith Bean. As Nisha did such a great introduction. Thank you, Julian, for having me today. I'll be talking about the digital asset landscape and the Digital Asset and Registered Exchanges Act in the Bahamas. We can move to my first slide. I'll give you a little bit of background to myself. I've been in the space since 2016. I'm an attorney. As they said, I have an office in Bermuda and an office in the Bahamas, and I support fintech companies in getting licensed in international jurisdictions. And so to talk more about the Digital Asset and Registered Exchanges Act in the Bahamas, in 2018, the Securities Commission was tasked by the government to introduce a new regulatory framework for the digital asset space. The Bahamas has been in the offshore finance world since the 70s, and they wanted to create a new pillar for the industry in the digital asset space. And so they circulated a bill with some regulations that were going to cover the digital asset business and financial technology companies. And so the bill was passed in 2020, and it is now in place. And the Securities Commission, after seeking wide consultation, was able to really bring a framework to the industry. As we all know, the industry was lacking some direction and some regulation, and many companies were seeking to have some direction as to how they would be able to operate their business. And so the Bahamas, as well as Bermuda, sought to bring those types of legislation and regulation to the forefront. You can change to the next slide. So the key features of the Digital Asset and Registered Exchanges Act was the actual definition of what is a digital asset. Digital asset representation of an asset on a digital ledger technology platform where value is embedded in which there is a contractual right of use and includes without limitation digital tokens. And so they define digital tokens as virtual currency tokens, asset tokens, utility tokens, non-fungible tokens, as we know, NFT, and any other digital representation of value designed by or designated by the Commission to be a digital token. And so the legislation does provide the Commission some wide approach to how they define what they think, what a digital asset is, and it allows them to somewhat create a framework for businesses that come up with new and innovative ways to provide services for digital assets. You can move to the next slide. So the Act states that digital asset business shall include the following types of business: token exchanges, provide services related to digital token um, exchange, operating the digital asset service providers, including DLT platforms that facilitate exchange of digital assets from digital asset currencies to fiat, any exchanges that deal with digital assets to digital assets, and any businesses that deal with the transfer of digital assets. Participation in provisions of the financial services related to any issues offer of sale of a digital asset. So anything that touches a digital asset is covered by this legislation. So if your business is providing services to facilitate, to custodian, to anything that has to do with the transfer or the exchange of a digital asset, it can be covered by this legislation. You can move on to the next slide. So as a result of the fallout from FTX, the Securities Commission thought it important to really do some in-depth look into the legislation and the framework that they created in 2020, because we all know that 1 year in crypto is like 10 years in every other business, and things change very fast. So at the moment, they have issued a consultation paper for the update of the legislation, which is being widely circulated throughout the Bahamas and the industry. And they are seeking for the industry to really give feedback on the updates on the legislation. And so, consequently, they learned a lot of lessons from the FTX debacle. And the commission is really trying to focus on how they can protect the digital asset activities and the ongoing supervision, and also protecting consumer and investors. And so, under the circumstances at the moment, they are still looking at new and innovative ways to bring in additional parts of the technology, but at the same time, creating a robust framework that's going to protect any users on these platforms. You can move on to the next slide, please. So the key features of the new legislation that they are circulating is the expansion of digital asset business. This section, the expansion is also through the operations of digital asset exchanges, custody of digital asset and custodial wallet services, staking and liquidity pool activities, issuers of digital assets such as initial token offerings, issuer of stable coins, and financial NFTs. What's likely not to be included into the bill is digital assets are part of any affinity or rewards programs, digital assets used within a game or sold as by the publisher or offered on a gaming platform, and issuance of privacy tokens, particularly within the Bahamas. And so they're really going to be focused mainly on creating more robust frameworks for the digital assets that are now keen to be on the market, much like security tokens and things of that nature, which are really hot topic items at the moment. And so, yes, the Securities Commission is keen on trying to support the industry. And as Julian said, IXSwap is also a part of that because they have recently gotten a nod for their license in the Bahamas. And so we're looking at the real development and growth of that industry there. And we're hoping to see a lot more companies reach our shores in order to set up their businesses and really take the industry to where it needs to be. So thank you very much. If you have any questions, I'm here to answer.
Thanks, Simone. That was short and sweet on the DARE Act. I think I have a few questions, but I'll keep it to the end. We'll just take it to Stephen. Stephen is our next speaker, and just to introduce him, he is a senior counsel with Piper Alderman, which is an Australia-based law firm. Stephen has been advising on financial services and fintech with a particular focus on the digital assets regulation. He has 14 years experience as a startup founder, which is great to know actually. And he's also a regulatory specialist. He's represented many firms and clients before the Australian Securities and Investment Commission, and even before the Hong Kong Monetary Authority. So with that, Stephen, I think I'll pass it to you to talk about the Digital Markets Bill that has come out in Australia.
Thanks, Nishita, and thanks, Julian. Thanks to InvestaX for hosting this event, and thanks everyone for listening in. As Nishita mentioned, I'm a special counsel in the blockchain team at Piper Alderman, and we, I think unique in this market, have a dedicated blockchain group that works with businesses in basically all aspects of the blockchain and digital assets ecosystem. I'm going to cover briefly the current landscape for tokens and digital securities in Australia, and then also touch on some of the exciting upcoming developments. So the key question in the Australian context, we don't yet have a bespoke digital assets regime. So the key question is a token a financial product? And that's a complex question. It's a very similar analysis to those who are familiar with the US landscape of looking at existing financial product or securities definitions and trying to work out whether or not something's more like a currency or a security of some sort. And we have a very similar test for something that's called a managed investment scheme that looks a lot like the Howey test as well. So we spend a lot of time thinking about those sorts of questions when faced with new offerings. At the moment, we don't have any case law in Australia on whether or not a token is a financial product or a security. So we're relying on relatively limited guidance from the regulator in something called ASIC Information Sheet 225, which basically says if it's one of these things that's in the legislation, then it's a financial product, but you really need to seek your own professional advice. So not overly helpful. So as I say, in that context, we spend quite a lot of time trying to work out whether something is going to touch that MIS definition, which I mentioned earlier. Notwithstanding those aspects, if something isn't a financial product and it is in the cryptocurrency space, there are still strong consumer protections which apply in Australia. So we have very onerous laws around sort of misleading and deceptive conduct, unconscionable conduct, etc., which do govern businesses that are engaging in dealings in relation to digital assets. In terms of the financial product side, so if you have a token which has those features which look like a security or a managed investment scheme, all of that is dealt with under the existing financial services architecture. Now, the digital security space is still relatively nascent. There are some funds that are launching in this market with tokenized offerings, but it's an area that we see as one that will have increasing growth in the coming years, particularly as some of the large financial institutions, the likes of NAB and CommBank and ANZ, are increasingly looking at tokenized offerings and stable coins as well, which is a sort of a key feature in the Australian context that will unlock some of the benefits and I think institutional interest in this space. We can go to the next slide, please. So as I say, if a token is a financial product, so it looks like a security or a managed investment scheme, debenture in the Australian context, then it fits within the existing financial services architecture. So if you're dealing or arranging in a tokenized fund or custodying interest in a tokenized fund, making a market, etc., then you'll fall within the Corporations Act and it will need to be licensed in the regular way. At the moment, some of the challenges that we have are around fitting digital assets within that existing architecture because we don't have tailored legislation at this point. But as I say, there are particularly wholesale investment funds that are moving into this space and starting to overcome some of those regulatory challenges, which is also partly a question of helping the regulator as well to upskill and learn in some of these areas. On the enforcement side, the regulator has been increasingly busy. Generally, the regulator has sort of taken the view that it doesn't have jurisdiction over a broad swathe of the sort of native cryptocurrency ecosystem, partly because of some of that uncertainty around what is and what isn't a financial product. So most of their focus to date has been on offerings that look something like an existing financial product. So to take some recent examples, last year there was a fund company called Holon Investments, which had 3 retail funds, single asset crypto retail funds. One was for Bitcoin, one was for Ethereum, and one was for Filecoin. And they had a look at the product disclosure around those products and basically decided under design and distribution obligations under Australian law that those funds were being too widely marketed to investors, to which it wasn't appropriate. Holon ultimately accepted and didn't fight that particular case, but it did set some flutters here around whether or not, once we do get a crypto licensing regime, whether the regulator will be fairly strict around certainly single asset crypto funds and other crypto offerings, how widely those can be distributed to retail, which probably touches on some of the conversations we're hearing as well in Hong Kong and Singapore. In terms of other cases, there was one against Coin, which was allegedly an unlicensed non-cash payment facility where you could purchase that token in order to make payments with merchants. We've had a couple of cases involving yield type products, one an entity called Block Earner and another one called Finder Wallet. Those were various iterations on the theme of investing Australian dollars in order to earn yield through different crypto staking or decentralized finance platforms. And then most recently, the local arm of Binance, which held a derivatives license here in Australia, after some ASIC review, and I think partly also due to some troubles they're facing in other jurisdictions, decided to hand in its license, which was ultimately cancelled by ASIC. And as others on this call may have heard, they've also recently, just yesterday, suffered some issues around debanking as well, which is currently posing some additional challenges to their Australian business. We can move to the next slide. Crypto is covered under existing AML CTF laws in Australia, whether you're in the digital security side or on the cryptocurrency side. Existing AML CTF laws will apply. There's currently a consultation going on to extend the scope of the regime, which currently is limited to conversion between digital currency and fiat currency in the pure crypto space, and they're looking to basically implement FATF guidance and to extend that to crypto transactions, ICOs, crypto custody, which we've seen in other jurisdictions as well. The timeline for that is still relatively uncertain, but we would expect those broader regulations around AML CTF to come in the next sort of 1 to 2 years. Next slide, please. Conscious of time, but I'll quickly touch on regulatory reform, because notwithstanding some issues around enforcement action and debanking, there's a lot going on in Australia, and I think there's some promising developments as well to look at. We do have an ongoing reform process and a commitment by the government to implement draft legislation on licensing and custody, which is primarily targeted at cryptocurrency exchanges, but will have broader scope potentially as well, and we could see more institutional players coming into the space. The exact form of that legislation is still under discussion. There's another consultation coming up in mid-June, but the promise is that we'll see legislation this year. I think it may end up being early next year, but the direction of travel, I think, is fairly certain that we're moving towards a licensing and custodying regime similar to what you see in other jurisdictions. There is a bill which has been put forward by a private or independent, a Liberal senator who's not in government, called Senator Bragg. And Senator Bragg has the Digital Assets Market Regulation Bill, which is currently under review by the Senate Economics Committee, and there's a consultation ongoing on that. Given Senator Bragg isn't in government, the likelihood of that passing, I think, is relatively low, but it's certainly keeping the debate live, and I think it's a very useful contribution to the overall conversation. I've touched on AML CTF, but the other big thing that's going on in Australia is the current CBDC pilot. A number of large institutions and startups are running various effectively tokenization projects using a central bank digital currency or derivatives of that in the sense of stable coins backed by that central bank digital currency called the EAUD. Some examples of that, it's being used for FX settlement, carbon credit trading and markets, tax automation, tokenized invoices, and a range of other use cases as well, including funds. And that's been, I think, a really useful exercise in looking at some of the real world use cases. And I think it'll be a bit of a game changer in terms of, I think, upskilling this market and sort of understanding some of the issues around digital assets and really the real opportunities that exist to create efficiencies and create more liquid assets and access a global market, I think. So certainly some positive things going on in that space as well. Thanks very much, Nishita. I'll hand over to the next speaker.
Thanks, Stephen. That was insightful and good to see that Australia is, pacing up with other jurisdictions and some promising developments that are coming through in terms of legislations and bills that are being drafted in this space. Okay, I think we'll move to South Korea. We have Uhun today with us. Uhun is managing partner at Cha and Kwan, which is a South Korea-based law firm. Uhun has been focusing on fintech and international law. He's also, I think, advising several blockchain companies when it comes to their cryptocurrency projects, STO offerings, and ICOs. He's a member of the Korean Bar Association and was also director at the In-House Counsel Forum, which is the largest in-house counsel society in Korea. So yeah, with that quick introduction, Uhun, over to you to hear about what's going on in South Korea.
Sure, thank you for the introduction. Next slide, please. Today I will discuss shortly about the regulatory frameworks in South Korea. South Korea is notorious for having a harsh regulation for investment and especially for foreign companies. However, regarding crypto assets, there actually has been a little amount of regulatory works here, although the local exchanges who dealing with fiat currencies are having a hard time dealing with the bank, which I will discuss shortly after. Next slide, please. So today I will be talking about 3 topics because the related acts in Korea are actually, I think, are 3. The first one is about AML. This is the only law currently stating about virtual currencies or virtual assets. We call this Acts on Reporting and Using Specified Financial Transaction Information. So this is the AML Act of Korea. The second act is the Financial Investment Services and Capital Markets Act. This is basically similar to the Securities Act in the US and deals with securities. Now, this law doesn't specifically mentions about virtual assets, but their interpretations. And recently they came out a STO guideline regarding this law, so that I will cover also. Thirdly, this is a new law which has not been enacted yet. It is called the Act on the Protection of Users of Virtual Assets, etc. So this will be kind of a general law for virtual assets that is not a security, which I will also, of course, cover. Next slide, please. So under AML law, we call it AML Act of Korea. This is the only law that defines virtual asset in Korea. However, the main focus of this law is about regulating money laundering activities. So like many jurisdictions, we do follow the guidelines by the FATF, and this is the law to cover that area. Next slide, please. So the definition of virtual asset is in here. It's very broad. It's defined as electronic representation that has economic value and can be traded or transferred electronically, including any rights therein. So the virtual asset definition of virtual asset is very broad, in my opinion. However, we usually cover cryptocurrencies with this. Now, we do have a definition for VASPs, the virtual asset service providers. It is would be any of the 6 activities. It can be covering not only one, but maybe all of the six as well. Next slide, please. However, in practice, the KOFIU, which is the main body regulating the AML activities in Korea, categorizes VASP as 3 categories in practical sense. So they have exchanges and custodial services and wallet services. So if you apply for VASP in Korea, they will ask whichever of 3 would you fall under. Now, if you want to act as a VASP, have a business as a VASP, you need to obtain license. However, it's a bit different, in my opinion, than other jurisdictions where you will have to have a prerequisite on the ISMS certificate. This is a information security management system kind of a certificate similar to that of ISO in global sense. You need to obtain this before applying for any licenses. Now, this is more of a hardware issues that your company has to get before the licenses. And if you want to deal with fiat currencies or cash, if you say, a special arrangement with local bank is also a prerequisite. Now, this is very difficult, actually. The law is very simple on this. However, the bank is very picky on choosing which exchange that they want to work with. So there are only 5 major exchanges in Korea who has made an agreement with bank. And as some of you may know, Binance is trying to get into Korea, and how they're going to come in is that they want to acquire one of the major exchanges called Gopex, which has actually a deal with the bank on this issue. So if Binance comes to Korea, they want to have an exchange that can deal with fiat currencies. Next slide, please. I don't think I have much of time, so I will go quick on the rest of the slides. But the next law that I want to talk about is the Capital Markets Act. This is the Securities Act of Korea. Now, the interesting thing is that this doesn't talk anything about cryptocurrencies. However, recently they came out a STO guideline. So this guideline provides certain criteria for a digital token to be categorized as investment contract securities. Now, investment contract is not the same as that of the US, because in Korea we have a certain criteria to be regarded as securities, which is different from how we test. However, it's pretty much similar in the details. So the guideline will provide how a token will be regarded as security, and how the government will draft a new law on the security token transfer market. Next slide, please. So how do you define, how do you categorize a token as security? the guideline gives us some examples or some criteria on the tokens. So if a token represents as an equity interest in the operation of a business, or if it has a dividend rights, or it has some claim of the assets, or let's say the issuer attributes profits to the investor based on the performance of the businesses, or the payments to the investor constitutes a distribution of risk profits. These are the examples of criteria that will be that a token would be regarded as security. However, this is not a law. This is just the criteria that the government has provided as an example. They say that they will look at the criteria on a comprehensive basis, on a case-by-case basis. So that interpretation is quite open and vague. And the government is actually saying that it is the responsibility of the issuer on whether the token will fall under the category of security. Next slide, please. So this is actually, I think, is more important because this is where the token is unlikely to be considered as security. So if it's just a form of payment, then it's not a security. If it has no promise of redemption or it goes on, then this is actually the first time when the government has said that this is all the examples of where the token will not be regarded as security. Next slide, please. Regarding security tokens, the government is saying that it will be regarded as a security, but like electronic security. So we do have a specific law on this, on electronic securities, where you deal with where you deal with electrified securities and not those that have a physical presence. So the FSC, the government, is saying that they will amend the existing law to get this electronic securities for the tokens. They say that the alternative trading system for security tokens will be allowed. However, that will require the amendment of the law as well. Next slide, please. The interesting thing about this ATS and the issuance of the security token is that the government does not like the crypto assets to be involved in the security token platform. So if you're using DLT, the distributed ledger technology for such security tokens, it should not use virtual assets. So this should be segregated. And ATS, the trading platform, cannot list its own token. So this is different from the approach from other jurisdictions in Korea. The Korean government is very hesitant of letting the traditional token cryptocurrencies to mixed with security tokens at this point. Next slide, please. So let me just quickly touch on this. This is a new law to be enacted within this year. This is called the Act on the Protection of Users of Virtual Assets. This will be the general law for non-security tokens. Its main focus would be on consumer protections, those who are trading within exchanges. So this is, at this point, this basically regulates the activity of the exchanges and the tradings thereof. We don't have any law regarding ICOs in Korea right now. So regarding ICOs, this will currently Korea has no regulations on that. Can you go next slide, please? So this is the details of the law. However, for the sake of time, I will end the slide here. If you have any questions, please let me know. Okay, thank you very much.
I think protection of users of virtual
Okay.
asset legislation. Yep.
Okay, great. As you know, we have a very big issue on Terra and Luna tokens. Although I think that is more of a global issue, that the Koreans are very are interested on regulating and preventing such activities. That's why this law has come out very quickly. The legislation was the both ruling party and the opposing party was had no concerns on passing this law. This governs on the activities within the exchange. I know that many foreign investment companies do have stake in the Korean exchanges because we have a large amount of dealing within the Korean exchanges. But this law now will have some power to grant the power to the FSC, the Financial Service Commission in Korea, to conduct any supervisory inspections to see if there are any illegal activities on the trading area. So the definition of illegal activities is vague at this point. We are still waiting for the presidential decree, which will detail the activity detail the definition on the law. However, before this law, there was actually no regulation on the activities of any traders within the exchange. However, after this law, there will certainly be some kind of boundaries where the traders can act. The details have to come on the later period, but it will come within a few months. So we will keep you updated on that as well. So I think that concludes my presentation. As you know, and as like any other jurisdictions, the law is quickly being amended in Korea as well. So we do see a lot of changes. If you're interested in this market, I advise you to keep updated on the changes. Thank you.
Thanks, Zuhon. That was insightful again. I think like many other jurisdictions, Korea is trying to segregate between crypto assets and the security tokens with different legislations for both categories. Okay, I think we have 10 minutes to go for the question answer round. I see some questions on the board from the audience. This one, so I'll just pick up what we have first from the audience, and then maybe I have my own set. This is for Stephen. Is there was a proposal for DAO recognitions a while back in Australia. Is that something which the Australian government is considering?
That's right. Yeah. So in 2021, there was a Senate committee that looked at a number of aspects of digital assets, and one of the recommendations was to look at recognition of DAOs. That recommendation hasn't been taken up by the current government at this point. I suspect that the focus will remain for the time being on putting in place a custody and licensing regime for exchanges and intermediaries. Stablecoins is also an area that's under discussion. I think DAO recognition, we're probably a few years away from that in the Australian context, but we can live in hope.
Yep. I think DAO is increasingly gaining recognition, at least in US and other parts of Caribbean. I think thanks, Stephen, for that answer. The next one actually I have is for Simone. So I think we discussed this, but you mentioned that Bermuda has the DABA Act, which has categories of license, full license, modified license, and then there's another tier. Is Bahamas also planning to implement something like that? Because many of the startups that that reach out for license may be bootstrapped, and the base capital requirements might be a lot when you have to get a full license. But is there some sort of gradation between licenses that Bahamas is considering? Simon, you're on. Okay.
This is something that we have been in discussion with the Securities Commission of the Bahamas for the past 2 years. I've been a strong advocate for having an introductory license for new companies coming into the sphere, because as startups, like you said, it's bootstrapping is like the way you get started, and not everybody has $1 million to get their technology off the ground, and people need to have a nice and supportive space in order to develop their platforms and to really prove their use case. But they have yet to take in a proactive approach on creating different license categories. They're really seeking organizations that may have already been established or have already established their technology and production, and also may not have been started in operation, but have really been well funded and ready to go. And so it doesn't always mean that the best person comes, because some companies who do have a lot of money may not always be the best companies to introduce. But under the circumstances, I'm hoping that they do change their approach quite soon. And as part of the consultation open policy that they have now, we're going to be suggesting that they give a tier approach and have somewhat of a sandbox in place so that they can assist companies to get from 0 to 100. But at the moment, they have been haphazard at doing so.
Yep. Okay. Thanks for that. Yeah, I think as a company also, we would like to push that category approach for licenses. Okay, I think we have
Certainly.
another question from our audience. We have another question from our audience, which is from James. And please, any of the speakers can take this up. In your respective jurisdictions, do security tokens constitute a security itself, or is it merely an on-chain representation? And if it's the latter, which is if it's just an on-chain representation, when would the token constitute ownership of the underlying security? I think that's an interesting question, because there's been a lot of confusion about mirror tokens, which are just an on-chain representation, and when does that on-chain representation become a security in the real sense. So any of the speakers who would like to just take on and explain it from your jurisdiction's perspective.
Certainly. So there has been some confusion with the way our legislation is set up in the Bahamas, because we have securities legislation that is operated by the Securities Commission as well. But they've taken the view that anything that is defined as a digital asset or touches a digital asset or on a DLT platform is considered a digital asset. And it may act as a security once the valuation of the security, or how it's passed to the ownership and how it's held, is determined by the platform. And so they seek to have regulations that are going to be specific to those platforms that are creating those types of products and services. And then they wish to create those parameters as on a case-by-case basis. They're writing the legislation to allow them to make changes as they go along, or to require additional oversight for the activities that you carry out. And so the short answer is that if your DLT platform is issuing security tokens, and they are meant to be like a security where you have some ownership in the platform or some ownership in some other type of product or services sold on the platform, then they'll be creating parameters or regulations for those activities, and possibly using some of the positions in the Securities Act that they have currently and putting that upon you in the under the Digital Asset Registered Exchanges Act. And so because of their keenness on trying to cover that, they want to keep the activities somewhat separate, but allow them to be able to give that oversight when necessary.
Yeah,
Um,
I think,
in-
yeah, Stephen, please go ahead. No, I was just thinking that the jurisdictions right now, they, at least what we discussed today, most of them are still trying to understand how to, come out with legislations that segregate between security tokens versus other virtual assets. There is definitely, a much advanced approach when it comes to Singapore and Hong Kong, where there's already legislations in place or guidelines from the regulators saying that, this is a security token and this one is a virtual asset. So, which at least what I hear is not the case in Australia, Bahamas, or South Korea, and it's still a work in progress.
Nishtha,
Stephen,
if I may just comment.
Yeah.
Nishtha, if I may just comment, my observation is that most of the regulators, in terms of categorizing security tokens, are taking I want to leave this flexible approach and using a lot of the, which I find quite ironic, the Howey test, which is quite antiquated, from the 1940s case law to, I think even Stephen said it mirror, the way that the regulators in Australia are looking at it is very similar to the Howey test, which I think needs updating. Right. And I think it's because that they still want to leave enough room and flexibility for them to then adequately address as the industry progresses. And it's similar to what it sounded like Ohun was saying in Korea as well. But yeah, maybe Ohun and Stephen can comment on that. That's my observation.
Yeah, I mean, I think that's
they
right.
also.
Yeah.
Sorry, go ahead.
I was just gonna say, I mean, the definitions are very broad. I think we'll probably struggle to convince them to confine them, but what we need really is some additional guidance on the regulatory side in the absence of court sort of decisions that start to demarcate some of these things. Even if we end up with a licensing regime for digital assets in Australia, there's still going to be the sort of perennial question, is it in that regime? Is it digital asset? Is it cryptocurrency, or is it in the financial services context? So I was interested to hear Ahun's comments around there being some additional guidance in Korea on those aspects for the regulator, because I think that would be helpful.
Yeah, so I do agree with all the comments here. And regarding the question, which is an interesting one, in Korea, the law is being amended so that the security tokens will constitute as a security itself. They're amending the law to define who can issue the security tokens, which will be regarded as security, as well as the platforms which can deal with those security tokens. And that is the future. However, as of now, that we understand is that any tokens that has the qualifications as a security will be regarded as security, but that is more of an on-chain representation as of now. We don't have laws regulating the issuance and the secondary market issue of those on-chain representations, though that is quite blocked. We don't have any possible ways to do it for a public offering of such on-chain representation as well. So the law in Korea is going towards to allow the token itself as a security. We do see in the future. However, I don't know if that will be very open business because there will be restrictions and prerequisites for the companies who are interested. However, we are going forward in that way in Korea.
Ohun, can I just follow up? When you say currently it's on-chain representation, so that means you have securities, traditional securities, then you tokenize those securities, right? And what you're talking about in the new legislation is when it's not considered a representation, it's a issuance directly on the blockchain. Is that correct?
Correct. Yes, they're allowing the law to capture that kind of issuance.
So then potentially in the future, once this law is passed, there could still be two types of tokens, one which is a representation and the other one is a blockchain native security.
Correct. The blockchain native security will be more regarded as a public offering to catch more audiences. However, at this point, what I see is that for securities that it's only the representation, we don't have any public offering regulations on that. So it's actually not allowed in that sense. But private offering, in my opinion, we don't have any regulations on private offerings, as long as it's private. However, for businesses, they will prefer public offerings, of course. So
then in that sense, does that mean you can actually touch retail investors?
If it goes public, yeah, you could go to retail market in that sense. Yes.
Wow, very interesting. Okay. Very interesting. I think that there are a few jurisdictions already which have changed their legislation to recognize digital native securities. But yeah, to hear that in our region, I think it would be one of the first in Asia, if I'm correct. Yeah. Sorry, I hijacked your conversation.
No. Yeah, I think that's correct. We've heard of blockchain native securities being recognized in Switzerland and Delaware as well. But at least in Asia, maybe Korea is the one which is leading if they come up with something to recognize native offerings. Okay, I think we are just on time, and we don't have any more questions as such now. So I'll wrap it here. Thank you, speakers, and thank you everyone who joined us today. We keep doing master classes. This was our second class, and this is a part of our learning and development efforts in the space. So please watch out for the space, and we might again come up with a masterclass with another interesting jurisdiction to hear on what's going on and learn from each of these jurisdictions and apply to our own businesses. Thank you again, speakers, as well as the attendees. We'll send you the recording of the webinar. Thanks, and have a lovely weekend ahead.
Stephen, thanks.
Thanks, everyone.
Thank you, everyone.
Thank you.
Thanks, everyone.
Thank
Nice
you.
to